feel, I mean, you know how you just feel a little under the weather?
Yeah.
And then yesterday my eyes were just like watering and I couldn't stop it. It's like, I don't know if that's that or if it's allergy. So, yeah, that was. She still sounds sick. You saw something. And he's the guy. Figured it was. Yeah, so today's not bad for me, but you got your hair down.
Yeah, chopped.
Yeah, looks good.
Thank you.
I was like, I go look up from it. I'm like, who's that up there?
Nice.
See it.
Oh, you're crazy.
We're our own worst critics. You know.
Right.
But yeah.
Oh no.
I thought she goes by accident. Yeah, I got it. Yeah, no, she goes by Randy. Thank you.
That's positive.
Cyrus, eat your breakfast. You wanna go to Erica's, don't you?
This year, Mr. Mellow. That's I remember it, real. Ariana was kind of just. I think the number. Yeah, that's it. He got moved, then he got. No, not that guy, but it's very, very. Oh, you know, I never. Maybe. Getting dirty awareness. I feel like I really know. I mean, it's not true, but it feels like, but it's like, how quickly a year?
All right, Superior Court of Appeals, Pennsylvania, second conversation. Judge Charles Eden Green, office, closing out order. You see it?
You say, normally I trust but verify. Today is just trust. Oh, that's right. I gotta get up on Zoom. Strange. Hmm. That's odd. Trying these out even and it didn't come out correctly. Can you do me a favor and Kathy, print me out another calendar? I have enough to go, but for some reason the middle pages didn't count. I have position 1, 2, and then it jumps to 10. It sounds like a Chuck problem, but I don't know why it has done this. Or an IT problem. It's never my problem. Thank you. Okay, so we'll do an out. Well, I'll let you go ahead and print it out since you're rolling. Believe it or not, I was ready. I was told not to come in here. Yeah, don't bother stapling it. I'll just fit it. Thank you. That's good. Okay, we'll go ahead and take announcements on the calendar first. So this is the August 14th final plea calendar. So it looks like Mr. Bell has positions 1 through 4. Mr. Clark?
Yes, Your Honor. And what I would ask for on positions 1 through 4 is that these cases be reset. If Your Honor recalls, Mr. Bell had previously been scheduled to appear before the court. I believe back in May was the last final plea date. It may have been June. He was in FTA status. He's obviously been arrested. I think more pertinent to that, though, is he has additionally picked up 2 new felony charges. If Your Honor recalls, we had talked before about coming to a global disposition on these 4 cases. He has other unindicted cases, and now he has 2 new further unindicted cases. So I think we need more information on those new charges, need to wait on indictments. I've spoken with Ms. Clark about this request. My understanding is the state doesn't have an opposition to resetting this to a further date.
Ms. Clark?
Good morning, Your Honor. Yes, that's correct. PD Clark and I previously discussed, and we're not opposed to the case being further noticed.
And the reason being, he was just picked up, and
Yes, Your Honor. So he was
the globe keeps getting bigger for the global sentence. It
correct,
keeps
Your Honor.
expanding. That's correct.
The state intends to file a motion to revoke his bond on the other charges. But he has the 4 indicted cases that are before you, but there are 3 unindicted cases that were there before he was arrested on 2 new charges back, I think it was between June 14th and 16th. So those are 2 different cases.
How long do you want to reset it for, Mr. Clark?
I'd ask for, I guess, 60 days to
Okay.
see if we can do that. And if the state files a motion, obviously want to have, adequate opportunity to prepare, but he's in no bond status on those new charges anyway. So
All right, we'll reset all 4 of these for 60 days. Position 5, Mr. Washahoon. These are really just announcements at this point, Mr. Wilson. That's right. Yeah, she's asked that we all do that. Ms. Clark is.
Your Honor, we submitted a sort of counter offer on Friday, and so I'll need some time to talk with ADA Clark. I believe this will be able to resolve today, but I need to talk a little bit more with ADA Clark.
Okay, we will circle back around then. Thank you, Mr. Wilson. Mr. Hornsby Wilson. For some reason, it's just listing as Wilson on here, so I apologize.
Either one was.
Okay. Oh, all right. Position 6, 7, and 8, Jaleel Tucker. That's Mr. Clark's case, so. 6, 7, and 8, Jaleel Tucker.
yes, Your Honor. And I believe Ms. Oakham is on this case. I discussed this with Ms. Oakham. She had placed an offer on the table. I have not had a chance to convey that to Mr. Tucker yet. I'm going to speak with him. If we can get it resolved today, I can make that announcement to the court. More likely than not, I'm imagining this is going to need to be set off. There are several co-defendants on position 6 that I believe have just got attorneys. I do want to have it on a trial calendar as soon as possible in case we can't reach a resolution today. And then position 7 and 8, I think would be are far less serious charges, which just need to travel along with whatever happens on position 6.
All right, we'll circle back on those 3. Position 9, Joseph Woods.
Your Honor, ADA Clark for the state on that. Defense counsel was served discovery and an offer on that case. So just waiting to
Is
hear
that-
back.
Is that Joe Brown?
Yes, Attorney Joe Brown, and to my, the defendant is in custody, Your Honor.
Yeah, I see that. He's been in custody for a good bit. I guess Kathy, can you try to reach out to Brown? Have you actually had any responses back from Mr. Brown, Ms. Clark?
I have, Your Honor. I know that he was waiting for an offer from the state, and so I provided the offer to him on, I think, on Thursday.
No, that's fine. I just was
Okay.
wanting to make sure it wasn't going into a black hole. That's all.
Oh, yes, yes.
Okay. Okay, we'll circle back. All right, so position 10 and 11, Mikhail Floyd.
I'd like to speak with Mr. Floyd, Your Honor, before making an announcement.
Okay. Oh, yes. Okay. Position 12, Miss Nizia Reeves.
Email, he did not file anything on this.
Oh, yeah. Yeah, I'll make, okay, so what's going on with Reeves?
He sent an email out on 10.
All right.
Judge Eden,
Yeah, if you didn't hear that, Kathy just told me that, so Reeves's attorney Kendrick sent us an email that he wasn't gonna, he's in a trial, but did not file anything with the clerk's office, so.
okay. I know that that is ADA Iqbal's case, and she authorized me to state that the state is ready for trial on that case. However, we would need a date certain, as there are out-of-state witnesses, so there's the interstate compact.
That's right.
Yeah.
And I remember having that in my notes. I don't have them today, but yeah, I know you need a date certain for witnesses. Well, there's no point in making that announcement now without the attorney here, but let's sit down and look at the calendar, and we will try to come up with a date certain trial out of state.
Thank you, Your Honor.
Thanks. Witnesses due to out of state. I know this announcement's been made a bunch of times, so we might as well get this on a calendar specially set. Position 13, Larry Sanderson.
Email from our colleague saying that he was getting married and on his honeymoon, but I don't know when that is. I don't know if it's this week, next week, next month, whatever.
I don't know if you heard all that, Ms. Clark. I mean, I guess this is a Macaulay case, but Kaplan's sort of AWOL. People have their theories as to where he might be.
Yes, Your Honor. The for this particular case, the case is expected to resolve on a plea. The defense attorney, though, is on his honeymoon. And so they're needing a date certain to do the plea at some later date.
Well, I was just going to say that the date certain was today, but nothing was.
Right.
But
Other than today, Your Honor.
nothing was filed. Oh, my Lord. All right, well, just let's reset this for a tight. Well, since everybody seems to know but me, how long is Mr. Shaw's honeymoon going to be for? I mean, is this? Is this in the Turks and Caicos or is it in Helen? I don't know.
I don't know. Probably, Your Honor, we probably want to just go ahead and reset it 30 to 45 days.
30 or 45 days. Wow.
Yeah.
Let's reset it for 30 days.
Yes, sir. Thank you.
Because, all right. All right. Position 14, we reset it. That's right. I remember. Position 15, Hasley. I see Mr. Hornsby Wilson, you have that as well.
Your Honor, that likely will resolve in a global plea, but we are waiting for, well, ADA Clark, I was wondering whether or not we were able to get that second case accused yet.
I'm waiting to hear from my legal assistant to see whether or not it was filed, but we should be able to have it done today.
Could we possibly, because I know we have final plea tomorrow, could we put it on for tomorrow? No, not at all.
Today and Thursday are in person.
On Thursday, so it needs to be today.
Well, I'll tell you what, we'll I didn't catch the last, so there's no way that the other case that's out there's no way that it's going to be able to be addressed today, Ms. Clark?
What I was saying, Your Honor, is that if we had I would say shortly after lunch, we should be the case will be accused and filed. So we will be able to take the plea today on both cases, if that is fine with Mr. Hornsby Wilson and his client.
Yeah, I just need to speak with my client for briefly, and it should be able to be taken today.
Okay.
We're getting that accused. It's unindicted currently.
Yes, and I'm having that case routed to your court, Your Honor. I'm working on it, Mr. Hornsby Wilson.
Okay. Position 16, Duval.
So there's kind of a lot going on with this case, Your Honor. So Mr. Duval has another case that is currently in Judge Cox's courtroom, and the victim in that case is one of my clients. And so I'm coming off of, well, his name is Treviel Oliver. I am coming off of Mr. Oliver's case, or at least I have petitioned to come off of Mr. Oliver's case. But in addition to that, I assume potentially Mr.
You're saying Mr. Oliver, you mean Duval?
No. So the victim in Mr. Duval's second case is Mr. Oliver, who is also my client.
Which sounds like that could be a conflict. I don't know.
Just a little bit. So I have already, or at least I've written and I'm waiting for it to be filed, my motion to withdraw from Oliver. But in addition to that, I don't want the appearance of any impropriety with Mr. Duval, because if his cases go to trial and I have to tell, or I've told him that I previously represented Mr. Oliver, I don't want him to say that I didn't do my job because I previously represent somebody else.
So what do you want to do with this case?
So with this case, I've already spoken to my boss. It's going to be reassigned to somebody else in a different division of our office. I believe it's going to be Rhonda Hill, but I'm not 100% sure. So in this particular case, because I know we're still waiting to see if the other case is going to actually come to this courtroom because it hasn't been transferred yet, we would ask for a reset. I spoke to ADA Charles.
Why don't we see if this can go to the other courtroom?
Well, this is the older
I'm
case.
kidding. I'm kidding.
But ADA Charles spoke about some outstanding ballistics. She said that there's a rush on it, but that could take, I think she said between 14 to 30 days. So, and I know I can get all of the discovery to.
What's the big charge on the other case?
Aggravated assault.
Okay. All right.
So I think a reset to, I don't know, if a final plea calendar to see, whether or not what's going to happen with the other case. And again, I can get Ms. Hill up to speed in terms of turning over all the discovery that I have, but I also don't know how long it's going to take to get the ballistics back in this particular case.
You're saying reset it for another final plea calendar.
Yeah, I mean, technically, I'm not the attorney on this anymore, so I imagine, we can't do anything today, but I don't know how long it would take Ms. Hill to get up to speed.
Fair enough. All right. Well, let's reset it for 60 days then.
Okay.
All right.
Your Honor, if possible, could we reset it for 60 days for a case management? To make sure that the new attorney gets discovery?
Let's reset it for 30 days for case management then.
All right, thank you.
All right,
Thank you, Your Honor.
all right. Position 17, Jamal Harvey.
Your Honor, I am present on that. I just received discovery on that particular file at about 4:30 on Friday. I still am not in receipt of the body cams. I've reached out to the state and haven't really heard anything.
You hear that, Ms. Clark?
I heard most of what Ms. Jones said, but she said she needs the body cam, and what was the last thing she said? I'm sorry.
That she's reached out and hasn't heard anything.
Okay. I will ensure that 88 Iqbal gets the body cam, or at least works on getting that to her. So I presume, Your Honor, the case will likely need to be reset for another final plea so that the appropriate discovery can begin given to PD Jones.
Yeah, I don't know. I don't know how these pleas work, you know? I don't know how attractive the offer is to your
Well, I
client,
haven't
but,
received any.
oh, okay.
I've been reaching out on this case for months, and finally I got discovery on Friday afternoon, but it's been like a dark hole. trying to-
Okay, so you still need an offer too.
I'd like somebody to discuss the case with, yes.
Okay.
Okay, so she needs body cam, wants to discuss the case and also, you know, an offer.
Okay.
All right, so what do you want to do? Reset this for 2 weeks or 30 days? What do you?
We could probably reset it, Your Honor. I just want the record to be clear. He's in custody,
I see that.
but I can't move forward unless I have the body cam and go over the discovery with my client, who has been asking for it for a very long time as well. So I will be providing that to him, maybe today, or I'll put it in the mail for him, but he's requested it.
All right. I'll tell you what, I don't know what we have coming up in the calendar, but if you have something within 2 weeks, let's do that. So it'll be 30 days. All right, we'll reset it for 30 days then. All right. Position 18, Troy Pitts.
Good morning, Your Honor.
I remember this one and see Mr. Trepanier. How about Mr. Wright? Is he around?
I have not seen Mr. Wright on the Zoom today, Your Honor.
Yeah, Mr. Pitts, Mr. Trepanier, have you been talking to Mr. Wright at all?
We, I know that there was an email exchange with the court, I believe, last week regarding possible conflicts with I think the upcoming trial calendar.
Yeah.
And I also filed a conflict for the trial calendar call on the 28th because of that 2-week 14 SC case that's coming up the 21st and the 28th. And so that was I guess the last communications that we've had.
You've got a conflict with the 14 SC case, right?
Yeah, so for the week of the trial calendar call and that week, I have that conflict with the 14 SC case.
For the record, I mean, I mean, it's not much of a record because I don't have the case number memorized, but I've mentioned to y'all on the phone, but since that's with a senior judge, just to be clear, we are continuing that case. So
That, well, and that was for Mr. Vernon.
the Vernon
Spear.
Spear, yes, the Vernon Spear case.
Yeah, and that was set for the 21st. Mr. Pitts, I believe there's a trial calendar call on the 28th. Your Honor, that Mr. Pitts is also on.
Sent an email to Mr. Wright. We asked on the 28th. I sent him an email saying, let's make that announcement for the final plea on 14th.
Yeah.
He says, I start trial on the 14th, but I was in a conflict soon with that announcement. But you have to do everything, so I didn't hear anything.
Why, I know, but I agree with you and follow up with him that he needs to file a conflict. I mean, there needs to be a conflict in there. There needs, record needs to be developed, but you're saying that you have a conflict on a 28th also because of all the other.
That much older case, Judge.
All right, more than likely, this is going to be a continuance. Let me brainstorm with my staff a little bit about this, but more than likely, and we'll get back to you on it. Okay, Mr. Trapanier?
Yes, Judge. All right, thank you.
And let Wright know that he's got to file that conflict letter. I mean, I don't know if he needs to rush out of a courtroom just to announce that he's got a conflict, but tell him to get that letter in, though. I want that letter. Because Trepanier's got a conflict as well, so there's no point. They've all got conflicts with judges that are more difficult, I guess, or more unbending, I should say. Position 19, Arnold, John Travius Arnold.
So the attorney
Yeah.
sent an email. And said that he is representing that apparently Patterson taking over case and that has not been filed. Okay. So
I don't have my notes in front of me. I'm trying to figure out why he's been in jail for so long.
Your Honor, if I may, this is ADA Clark for the state. The defendant has a murder case
Okay.
that has
all right,
been
now-
assigned to Judge Cox's courtroom, which is the reason why he has been in custody for as long as he has. Now, I know that the attorney Shada has filed a leave of absence, but Your Honor, it is the state's opinion that this case should be transferred to Judge Cox's courtroom to follow the murder case, being that the filing date for the murder case was the opening date for that case was in July of 2021. So it would predate this one. So that would mean that case, the theft by receiving stolen property should go to that case. The state has already previously filed discovery and served Attorney Shada with that. An offer for that case has also been provided. But for the murder case, Your Honor, to just let you know, I think that there is a motions hearing that will be set for that case in Judge Cox's courtroom. But I think that the appropriate thing would be for this case to be transferred there as well.
Yeah, but I mean, do you know, does Jackie, the fly lawyer Patterson, have the murder one as well?
Jackie the Fly lawyer, according to Attorney Shada, has the murder case. He does not have the case that you, the theft, but the case that we have before you. Attorney Shada is the attorney on that case.
I mean, I guess what I'm saying, it sounds like this ought to be transferred.
We can transfer.
Yeah.
but as far as this email,
Right. I agree, Your
Yeah,
Honor.
but
I just wanted
I
to-
guess there's a side of me that's wondering why get hung up on that email if it's gonna get transferred, all right. Seems like a technicality in my book, so.
I mean, the case needs to, even if Attorney Shada is a different attorney, the case will still need to go to Judge Cox's courtroom because that case
Yeah,
is
yeah.
the murder case is the older case.
All right, well, let's get that transferred and moved on, and move on. Position 20, Rasheen Walker.
I am present on that, Your Honor. I have received an offer. My client has rejected it, and I've tried to reach out to further discuss the case, but haven't really gotten anywhere, so I can just stay on the trial docket.
Who has the case? Iqbal?
Your Honor, it's Iqbal's case. She indicated that that she will get an offer to defense by the end of the week, and that it would need to be reset again for another final plea.
Not
Because
sure about,
she's in trial at this point.
was she on trial for the trial week? Is the question.
Mm,
Prefer just to leave it on. the
Yeah,
trial.
let's leave this on the trial calendar. I'm not gonna just boot something from the trial calendar, just. 'Cause somebody says they're gonna get another offer in by the end of the week.
Yeah, because we'll still
So-
have a calendar call, Your Honor, for this, so if we're
Yeah.
able to resolve it, we're able to resolve it, but.
so it'll be advanced to the calendar call. Okay.
Yeah, it's still
Okay.
on the trial calendar. so.
Okay, that's fine, Your Honor.
Your Honor, may my client be excused?
Yeah, yes, Mr. Walker can be excused. All right, position 21, Malik Murphy.
Yes, Your Honor. I'm asking for a reset on Mr. Murphy's position. I apologize. He was previously set for a final plea on June 5th. He was in FTA status then, and this case was placed on hold. He was picked back up. He has 2 new unindicted felony cases now that he was arrested for in the interim. In addition, I had spoken with the state about some missing discovery. There were photographs that were mentioned in the police report as well as body camera. I inquired about that to Ms. Iqbal, and I'm still waiting on those. So for all those reasons, and I don't believe I have an offer on this yet either. For all those reasons, we're asking to reset this position.
Ms. Clark, I assume you / Iqbal aren't going to have an issue with me resetting this?
No, Your Honor, the state does not oppose it being reset for
Okay.
the reasons that Mr. Clark has indicated. And I will make sure that this information is relayed to ADA Iqbal on the outstanding discovery and offer.
Okay. And then the next one is Swisherin, is that it? Bowen Swisherin?
Yes, Your Honor, that's my case.
Dan Klump from Mr. Shishirin. Judge, we have received an offer that we want to accept. My client is in a nursing home in New York. If we could do a plea in absentia, we'd like to do that. If we can't, then we just ask for some time where he can be cleared for travel to get here.
When you say an abstention, you mean over Zoom?
Yeah, we could do it over Zoom.
Would he be prepared to do it at some point today or?
Not today, Judge. And I apologize. I don't practice in Fulton primarily. I didn't know if we could do the plea by Zoom.
I mean, I always prefer them in here because inevitably the client has questions and it just doesn't go well over Zoom with breakout rooms. But I was going to say, I don't mind it as long as you and your client are on the same page and you've gone over everything and he's on board with it all. I don't mind him.
We recently received the offer and I just conveyed it and he's wanted to do it this morning. So I would like a little bit of time just to tell him how the plea is going to work and everything and to get any paperwork complete.
Well, when can we schedule a Zoom plea? Do you think? I mean, probably anytime, right? Because his client's in New York. It's not even a Zoom booth situation. So it's really at our leisure.
What?
Go ahead, Ms. Clark. I'm sorry.
Well, Your Honor, I think that the plea could actually be done this afternoon. If it's going to be done by Zoom, I'm not opposed to that. I was under the impression that based on what Attorney Klump had revealed regarding his client's medical status, that it would be done by Zoom anyway. So Ms. Robinson can provide the plea paperwork to him and the plea could be done this afternoon.
Well, I just want it to go as smoothly as it can, Mr. Klump. And so how much time do you need to go over all this with your client?
Judge,
I mean, the sooner the better, but I'm not trying to, it's going to be pointless if we race on this in the afternoon and then there's a bunch of questions and it doesn't go well. So,
yeah, I would like to do it any day, but today, I think if I could just have some time with him today to go over everything, I can be available any other day.
And that way we can figure out how to appropriately do the paperwork. So what are you thinking? Next week? Well, let's try to do it this week, but let's. No, tomorrow's final plea, more final pleas, right?
Could we, let's see, could we possibly do it in the afternoon tomorrow?
Yeah, I'm fine with that.
Okay.
Yeah, let's do that. Let's get him scheduled for a final plea tomorrow. Does your client have video accessibility?
He should be on right now.
Yes, I'm on.
All right. So who am I talking with right now?
Owen Sifcharan, sir.
There he is.
Okay, so you've got it all. You're teed up. So you'll be able to do this tomorrow over video?
Yes, sir.
Okay. All right. Well, your attorney's sitting here and we'll schedule this for tomorrow afternoon. And then the two of you can go over the paperwork and the waivers and all of the things that are required to do this properly.
Thank you,
Yes, sir.
Judge. And as far as any paperwork, would I? Okay, thank you.
Okay, sir. Well, you're excused for now, and your attorney will just talk to you as far as what time you need to be on tomorrow afternoon.
Attorney Klump,
Yeah,
if
well, I
you
mean, might
need-
as well figure that out now. What, like 1, 2, what's good?
1 o'clock is fine.
All right, so you'll be on at 1 o'clock. I can't guarantee you just the way things go that we'll do it right at 1, but we'll get you fit in somehow.
Okay, thank you, Your Honor.
All right. You're excused for now.
Sir.
All right, thanks.
Can I be excused?
Yeah, you're excused. Well, she's printing out the paperwork for you.
Okay, I won't leave without that.
Okay,
Thank
all right,
you.
thanks. Okay. Yeah, one more. Yeah, Mr. Klump, especially if the client is out of state and there's medical issues, I'm gonna more than likely be fine with that, doing a Zoom. So, okay, so position 23, Janie Ivory. Well, I see that.
That's my case, Judge. This is Tanya Miller on behalf of Miss Ivory.
Okay,
As I understand it, Your Honor, the state is announcing a null pass today.
Ms. Clark?
Your Honor, that is correct. The state, after reviewing, reviewing the case, we find that the arrest in this case was for probable cause. However, Your Honor, after review of the evidence, it is the state's opinion that the evidence does not rise to the level of beyond a reasonable doubt, and for that reason, we are going to dismiss the case against the
Okay,
defendant.
so you'll get me that paperwork, Ms. Clark?
Yes, Your Honor.
Okay, anything else, Ms. Miller?
No, Judge, that's it.
All right, you and your client are excused then, and I'll sign that no pros paperwork.
Thank you, Your Honor.
You're welcome. Position 24, Jones and Dana Jones.
She's here, Your Honor.
Okay. I see you.
And Your Honor, we received discovery late last week. And we don't have an offer on this case. So what I would propose is that we just stay on the trial calendar. I'm hoping that this will be able to resolve, and there's not really a lot of discovery, so I should be able to review it pretty quickly.
Ms. Clark?
Your Honor, yeah, thank you for giving me the state opportunity to be heard. Your Honor, yes, discovery was served to Mr. Hornsby Wilson. However, the state has decided to dismiss this case on the basis that the evidence against the defendant does not rise to the level beyond a reasonable doubt, and the state does not believe in taking cases to trial that does not rise to that level. So we will be submitting a null pros for this court to sign unless the defense opposes.
No opposition.
You want to y'all want some time to negotiate that? Or?
I think we're good.
All right, you can represent that on behalf of your client.
Well, thank you, Your Honor.
Okay, well, Ms. Jones, you're excused. I'm sure that's probably good news for you. And Ms. Clark, you'll get me that paperwork, correct?
Yes, Your Honor, and I will copy Mr. Hornsby Wilson on it when I
All
submit.
right. All right. Position 25, Okuwabi. Zoom, I see.
Yes, good morning, Your Honor. I'm here on behalf of Ms. Okwabi. She's also on Zoom.
Okay. I see she's muted right now.
Hi, Your Honor, I'm here.
Okay, we'll go ahead. What was your name again?
Olga Ismailova. And I
Olga
believe
Is-
that the state has an announcement in this case.
Okay. Ms.
Yes, Your
Clark?
Honor. The state has reviewed the evidence against the defendant in this case. And we are of the opinion that the arrest was one for probable cause. However, based on our review of the evidence against the defendant, if this matter were taken to trial, we would not be able to prove it beyond a reasonable doubt. So for that reason, we will be submitting a null pros to dismiss this case on behalf of the state, Your Honor.
Okay. Well, Miss Isla Maylova,
Ismailova, yes, Your Honor.
Maylova. You and your client are excused then.
Thank you.
Okay.
Thank you, Your Honor.
All right. Anything else we need to address before I take a break and y'all can speak with your clients and the other parties? All right. If you can pause the YouTube, I don't know how you do that. What? Up and up.
Ms. Robinson, Mr. Hornsby Wilson. Mr. Defendant Hasley's case, the second case, I have the indictment number for that case. So I'm gonna put it in the chat for Miss Kathy, and I'm gonna send you and her an email with that information. Okay.
Mr. Clark? Can you hear me? Mr. Clark, can you hear me? I'm not saying Mr. Okay.
Mr. Clark?
No, I know. Position 5, 22 SC 185-150. It's Abayu Washahoon, is that correct?
Washington, yes, sir.
Washahoon, okay. And he is present in the courtroom with his attorney, Mr. Brandon Horsby Wilson, and we have Ms. Clark. Are you?
Yes, Your Honor. Give me one moment so that I can
Okay.
adjust my camera. My apologies.
You see that Mr. Wright was in the chat?
Yeah, he was on, I think.
Okay. We'll wait till Ms. Clark is up and running here. We have, yes, Miss Christina Clark is online.
My apologies, Your Honor. Sorry.
No problem. He is on Zoom. So it's my understanding that you've got a negotiated plea to present?
Yes, Your Honor, we do.
Well, oh, so it's going to be you reading the plea. That's right. Okay, so Ms. Clark, go ahead when you're ready.
Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. Please state and spell your true, correct, and legal name.
Abeyu, first name W, last name Washihun.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
30,
I'm sorry, I didn't hear you.
30 years old.
Okay, thank you. What is the highest level of education or the last grade you completed?
11th grade,
Where did you attend high school?
Clarkston High School.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Count 1, aggravated assault. Count 2, possession of firearm by convicted felon. Count 3, possession of firearm during commission of certain felonies.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the waiver of rights form and the indictment with your attorney?
Yes, ma'am.
And did you understand the waiver of rights form and the indictment as explained to you by your attorney?
Yes, ma'am.
And is it your decision to waive your rights today and also to enter a guilty plea as you signed on the indictment?
Yes, ma'am.
Your Honor, the state at this time would move to have the waiver of rights form and the indictment entered into the record that's been signed by the defendant and his attorney.
So moved. Just from a procedural standpoint, obviously you haven't signed it, Ms. Clark. How do you want to go about doing that?
Your Honor, the state gives this court express permission to sign on my behalf.
Okay. Okay. Go ahead, Ms. Clark.
Thank you, Your Honor. Defendant Washahan, have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Would you like more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with your lawyer services, Mr. Hornsby Wilson?
Yes, ma'am.
Attorney Hornsby Wilson, do you waive a formal reading of the indictment for purposes of this plea?
So waived.
Do you waive any and all defects within the indictment for purposes of this plea?
So waived.
Your Honor, the state is unaware of any outstanding warrants related to the charges within this indictment. Defendant Washahan, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
The state will provide those for aggravated assault. The minimum is 1 year, the maximum is 20 years. For possession of firearm by convicted felon, the minimum is 1 year, the maximum is 10 years. And for count 3, possession of firearm during commission of certain felonies, the minimum is 5 years, and that must be consecutive to the underlying felony. Do you understand that today you are entering a negotiated plea of guilty, which means that the state and defense will jointly recommend the following to the court?
Yes, ma'am.
I'm going to review that, but give me one moment. I need to pull it up because I'm reviewing it from my computer screen. I'm sorry, Your Honor, just one moment. Mr. Hornsby Wilson and I had some renegotiations and I'm trying to access that.
Okay.
Sorry for the delay. Okay. if we could go off the record for a moment, Mr.
Sure.
Horace Wilson. So the renegotiated terms were 13 years to serve 2 in confinement, right?
Well, I would love it if it was 2, but I thought it was 3 from what my understanding was.
Okay, all right.
Now, if you want to give us 2, we're open to doing 2, but that wasn't necessarily what we negotiated.
Okay, no, I can't, for some reason, I cannot pull that email up
Would you like me to just sort of read out the crux
Yes,
of what we agreed
yeah,
to?
yes, please.
So on count 1, it would be 3 years confinement plus special terms during confinement. On count 2, possession of a firearm by a convicted felon, that would be 5 years probation to be served consecutive to count 1. And then on count 3, it would be 5 years probation, also to run consecutively. So in total, it would be 13 years to do 3 years confinement, credit for 838 days, which is the amount of time that Mr. Washington has served already. The balance probated, and then there are special terms for confinement and special terms for the probation. And the only changes that we made this morning to the special terms were that instead of 90 days to be able to get a job, he would be afforded 150 days. So
150 days, okay.
3 months to 5 months.
Okay, is it possible for you to re-forward me that email where you had actually laid it out? Okay, so I have it now. Right. Okay, Your Honor, we can go back on the record.
Okay.
My apologies. Okay, so the terms of the plea would be for count 1, aggravated assault, 3 years confinement, plus the special terms, plus the special terms of the plea as set forth below. Then 5 years confinement, plus the special terms of the plea as set forth below.
I think it was 5 years probation.
Oh, excuse me, 5 years probation. And then for count 3, possession of firearm during commission of a felony, it would be 5 years probation, which will be consecutive to as the special terms below. Special terms of the plea, defendant forfeits the firearm that was confiscated at the time of his arrest, and firearm shall be destroyed by the agency. Special terms of the plea, defendant is barred from using social media of any kind while incarcerated, and he shall refrain from any contact with the victim, Kavian Thomas. The DOC is authorized to administer a mental health and psychological assessment within 30 days of the final disposition of the case. And the state evaluation will be at the state's expense. As part of the terms of the negotiated plea, the defendant will complete all treatment recommendations and take medication if prescribed. Defendant shall remain compliant with all treatment, including medication, while he's in the custody of DOC. If the defendant has not been transferred to DOC's custody, the Fulton County Jail should conduct the mental health evaluation. With this plea, the defendant consents to a waiver of his health information to the state, limited only to the sole purpose of medical professionals confirming that he is completing the medical treatment and compliant with his medication. Defendant shall complete his GED while incarcerated, and the cost of his prep materials and the cost of the test will be covered by the state. Then special conditions of probation, defendant shall continue all recommended mental and behavioral health treatment upon his release from custody. He must remain compliant with medication. He is to have no contact with the victim, Kavian Thomas. no drugs unless prescribed. Defendant is subject to random drug screens. Defendant must not possess any weapons or firearms. Defendant must be gainfully employed within 150 days after his release from custody, and he'll provide proof of his employment to his probation officer. Is that your understanding of the terms of the negotiated plea in this case, sir?
Yes, ma'am.
Let me ask a quick question on that. So the first, the aggravated assault is 3 years confinement. Is that commuted to time served or credit for time served?
Credit for time served, Your Honor.
Okay.
Is it okay to continue, Your Honor?
Yes, please go
Okay.
ahead.
Do you understand that the court is not required to accept the state's recommended sentence in this case?
Can you repeat
Mr.
the question?
Washahan, sorry, can you hear me?
Can you say it again, please?
I said, do you understand that even though I've read the terms out to you, that the court is not required to accept the recommended sentence of the state?
Yes, ma'am. I understand.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that as there are multiple charges to which you are pleading guilty today, the court also has the right to run those sentences consecutively, meaning one after the other?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your plea of guilty?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes, ma'am.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence? And the special conditions are that the defendant, if recommended for mental and behavioral health treatment, will remain compliant with treatment and medication. You are to have no contact with victim Kavian Thomas, no drugs unless prescribed. You will be subject to random drug screens. You will not be able to possess any weapons or firearms, and you must be gainfully employed within 150 days after your date of release. And you must provide documentation to your probation officer. Do you understand that those are special conditions of your probation?
Yes, ma'am. I understand.
Okay. Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so will result in new criminal charges for which you face a sentence of between 1 and 10 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face up to a 15-year custodial sentence consecutive to the sentence for the underlying felony?
Yes, ma'am.
Do you understand that even after your probation is over with, that you can never carry or possess a weapon of any kind?
Yes, ma'am. I understand.
Okay. Do you understand that by that entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Defendant Washahan, is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 22 SC 185150, how do you plead to the charge of aggravated assault?
Guilty.
How do you plead to the charge count 2 of possession of firearm by convicted felon?
Guilty.
How do you plead to count 3 of the indictment, possession of firearm during commission of certain felonies?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes, ma'am.
At this time, the state will provide a factual basis for the felony plea in this case. If this matter had went to trial, the state would have been able to prove beyond a reasonable doubt that on April 14, 2021, APD officers responded to a person shot call at the incident location of 2469 Piedmont Road, Atlanta, Georgia, in Fulton County. A Black male was on the ground with a gunshot wound to his left leg and his right thigh. One witness assisted the victim, later identified as Kabian Thomas, by applying a tourniquet to his leg. Shell casings were observed in the parking lot. The VIC video camera showed the victim falling after being shot after he exited the Zesto's restaurant. A witness reported a Black male with dreadlocks was the shooter who left the scene immediately afterwards. Other witnesses said that they heard gunshots and saw a Black male fall to the ground. They ran over to assist him, but did not see the shooter. The victim was uncooperative when officers tried to talk with him at the scene. Thomas was transported to Grady Hospital and the scene was processed by the crime scene technisian Parker. Officers were provided video footage of the shooting, which captured the defendant, Mr. Abayu Washahan, pull up in a small gray vehicle, back up toward the incident location of 2459 Piedmont Road. He exits his vehicle and begins shooting at Thomas as he walks across the parking lot toward Home Depot. Defendant returns to his vehicle, sits for a minute or two before leaving the area. His vehicle was located at 635 Lindbergh Drive, which came back registered to Abayu Washahan, the defendant. His driver's license photo matched the picture of the individual that was found on the surveillance footage shown to have shot the victim, Kabian Thomas. The state will provide an overview of the defendant's criminal history. Pursuant to a GCIC, the defendant has a total of 15 cycles of arrest. The defendant has a 2011 conviction for burglary in DeKalb County. He has a 2011 4-count felony conviction for burglary in DeKalb County from 2011. The other offenses that the defendant has convictions for are misdemeanor offenses, Your Honor. His last offense was a criminal trespass misdemeanor conviction in DeKalb County, January 12th of 2021.
Okay. Mr. Hornsby Wilson.
Your Honor, Mr. Washington is 30 years old, and in talking with him, he has expressed that, he is willing to take responsibility for his actions in this particular case. As ADA Clark said, his criminal history, at least felony criminal history, is relatively limited to just the burglary charges over 10 years ago. This is the longest that he has been incarcerated, and he has expressed to me that he does not want to go back. So he's willing to do his time and spend his time on probation, and he just wants to be able to put this behind him and move forward with his life. And we just ask that you accept the negotiated plea.
Okay, Mr. Washington, do you understand the nature of the charges against you?
Yes, sir.
You just heard Assistant District Attorney Clark explain all the rights you give up by earning this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand the court is not bound by the recommendation or the plea agreement, and I can sentence you as I deem appropriate?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Mr. Hornsby Wilson, are you satisfied that your client is competent, understanding that the plea is voluntary and there's sufficient factual basis for entering the plea?
Yes, Your Honor.
Okay, I find there's sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and sentence you to the recommended sentence as follows. I may ask some questions along the way. There's a lot of special conditions in this one. So count one, aggravated assault, 3 years confinement, credit for time served. Count two, 5 years probation to be served consecutively. And count three, 5 years probation to be served consecutively. So 3 years of confinement with credit for time served and 10 years total of probation. Here are some of the special conditions. So upon release, 150 days to get a job. The defendant forfeits his firearm that was confiscated to the agency. And it's been mentioned already, but he's no longer allowed to have a firearm in his possession. No social media while incarcerated. No contact with the victim. When is he to have the mental health evaluation? Is that within 30 years? I mean, 30 days?
Of today is my understanding.
Okay. That's okay. That's what I thought. So mental health evaluation within 30 days of today, and it will be paid for at state expense, and he is to follow the recommendations and comply with any medication prescribed. The defendant consents to a waiver of health. The waiver is limited just to, is it to make sure he's in compliance of his medication, or what is it limited to again?
It's just limited to strictly to see if he is compliant with his medical treatment as a part of this plea and his medication. Yes, Your Honor.
Okay, so Mr. Washington consents to a waiver of his health information, but that waiver is limited to just what's needed to ensure that he's in compliance of his mental health treatment and medication. While he is incarcerated, approximately how much time does he have left on his incarceration? I guess about half a year.
I have it as 257 days.
So we have that while he's incarcerated. Is it to obtain a GED? Because I don't know if that's enough time to obtain a GED. I don't know. Is it?
It should be, but Your Honor, the state is fine with him just having until after he's released from custody. But but he must have it done within 18 months from his release from custody.
All right. So how about this? How about while he's in custody, he begins the process of obtaining his GED, and he must have it fully completed within 18 months of his release. Is that fine?
Yes, Your Honor. That sounds good.
Yes, sir.
Okay. And that will be paid for by state expense.
Yes, Your Honor.
We've already mentioned that he must continue, and then even upon release, he must continue to be to follow the terms and recommendation or to follow the recommendations of the mental health recommendations, including being compliant with any drug prescriptions. And I think that is it, but let me know if it's not.
You got it, Your Honor. No contact with the victim, KB and Thomas.
Yes, no contact with the victim.
Yes, sir.
Anything else?
No, Your Honor, that's it.
Okay, you're excused, Mr. Washahan.
Thank you, sir.
I know PD Clark has something, so can I step out and talk to his family?
Sure. What position do you have, Mr. Clark?
I have positions as we could do 6, 7, and 8 first.
Okay, well, let's bring out Mr. Tucker then, position 6. Well, position 6, 7, and 8, which is Mr. Tucker. Okay, so this is position 6, 7, and 8 with Jaleel Tucker, and the indictment numbers are 22 SC 1829555, 21 SC 1755536, and 22 SC 1800382, all respectively. Mr. Tucker is present in the courtroom as he's joined by his attorney, Mr. Clark. We have ADA Christina Clark on. Oh, Miss Oakham's doing this one. Miss Oakham, I apologize. How are you?
I'm only on the gang count. I think that's position 6.
Okay, so you're going to kind of do this jointly with Miss Clark then?
Yes, Judge.
Okay, so we have Miss Oakham, ADA Oakham, who is going to do the gang counts on position 6, and then ADA Clark will do positions 7 and 8. So there's a negotiated plea to present on this?
No, that's incorrect, Your Honor. We were conveyed an offer by the state. I've communicated that to Mr. Tucker. We're not able to reach a resolution at this point. So that's the announcement we had. Mr. Tucker has on position 6 is obviously the one that's driving the train. 7 and 8 are much less serious charges. On position 6, there are multiple co-defendants on that case. Those are not on the trial calendar for the 31st. As a reminder, I had filed a constitutional demand for a speedy on Mr. Tucker's case. So if we're not able to reach a resolution right now, I'd ask if the entire indictment with the co-defendants could be potentially placed on the September trial calendar. And
all right, Miss Oakham.
I'm sorry, Judge. Yes, Judge, that is correct. I conveyed an offer. The defendant has 4 other co-defendants. I don't know why only Mr. Tucker was on the calendar today. But on his gang counts, he has 4 other co-defendants on the case, Judge.
I see something on here. Give me 1 minute on this. All right. So we have this down on the count. So we do have it down on the trial calendar for.
For the 31st, yes, Your Honor. The co-defendants aren't on there. My understanding, though, is that the state intends to try it jointly among all 4 co-defendants.
That is correct, Judge. It's on video and all the
So the
his other
co-defendants do
co-defendants are
not have
all on
attorneys?
video for the same charge.
All right, so Ms. Robinson's whispering in my ear right now that 2 of the co-defendants just got attorneys.
I believe we were here on the 10th, July.
I don't,
10th.
unfortunately, I left my notes at home. I
But
mentioned this before, but
I thought at that time on July 10th that all the co-defendants had attorneys at that point. I don't know if that was more recent than then, but obviously my concern on Mr. Tucker's behalf is that he's been in jail for over 576 days.
oh, I get your concerns and I get your concerns are not the co-defendants. Your concerns are your client. Of what? All right. Has he been in front of me yet, Sheffield? What, how come we just have him down on a trial calendar? So Ms. Oakham, at this point, as you said earlier, your intention is to try all of the defendants together.
Yes, Judge, it's an armed robbery. It will probably take, I mean, I guess they're all 4 co-defendants, but the witnesses are it's not a murder. So the witnesses are not a lot, probably 12 to 15 witnesses. It's all on video, HD video. And all 5 co-defendants are on the HD video. And it's 1 victim. So they were all involved as part of the gang. So I don't believe it would take long to try the case. So, and there's no, like I said, it's on video. I don't see any severance issues unless the defense attorney files one, but it's on HD video. The video sort of speaks for itself. And I intend to try all of them together because it'd just be playing the same video in 5 different trials.
I see. Mr. Clark's got his demand for a constitutional speedy trial.
She has this case.
So as soon as we can put them all on the trial calendar, that would be fine with the state. For judicial economy, like I said, it's a video.
Yeah, where you can get pictures and stuff.
Yeah. Not today. Me in court 4 days.
So we're gonna have to just sit down and go through all the speedy trials and, because there might be some that deserve to be specially set. we're going to have to figure that out. We'll do that in the office. But as of right now, since these attorneys hadn't even been in front of me, I just don't see how I can force this trial to go at the end of the month. So what we'll do is we're going to try to get it in October. We'll specially set it. And then with that, Kathy, we got to make sure that we have some kind of a status or case management hearing to make sure all of the attorneys are lined up and ready to go.
Yes, Your Honor.
All right. Anything else, Ms. Oakham?
No, Judge. That
I'm-
concludes my matters. May I be excused after, obviously, you're done?
Yes. So that means that we're continuing 7 and 8, I assume, as well. Because okay. All right. Thank you, Ms. Oakham. You're excused.
Thank you, Judge.
Thank you, Your Honor.
Okay.
Your Honor, before we release the defendant, I wanted to make sure with 7 and 8, because an offer and discovery were provided. I just wanted to make sure, are those cases going to, does PD Clark intend on trying those cases?
Hold on to him for 1 minute. Go ahead.
I just asked that just given that there's one case clearly driving the train, I'd ask if we could set that off as well for those cases too, because in
Okay.
case we can reach a resolution with Ms. Oakham, then
We want it
wanna-
to be global.
We want those to roll in together, and so I'd ask if those could be set off till October too.
Okay.
All
Yeah,
right.
I figured that as much, but I just wanted it to be on the record.
Okay. All right. All right. Mr. Tucker's excused now. Who do you want to bring out next?
I have Mr. Floyd, Your Honor, and we just have an announcement on that.
No. All right. Okay, so this is, if we could just put this on the record, that 22 SC 184369, Joseph Wood's attorney was not present today. Okay, and who do you want to bring out next, Mr. Clark?
Mr. Floyd, Your Honor, positions 10 and 11.
All right, and that's an announcement?
That is, Your Honor.
Yeah, leave him on there. Leave Mr. Woods on there. I mean, Mr. Brown, like we didn't even hear through the grapevine where he is, right? Okay.
And Your Honor, for position 9, discovery and offer have been served. Defense counsel has had discovery since July 27th.
Okay. All right, so this is positions 10 and 11. Mr. McHale, Floyd, indictment numbers 22 SC 184369 and 22 SC 180357. He's present in the courtroom with his attorney, Philip Clark. We have Christina Clark with the district attorney's office. Go ahead, Mr. Clark.
Yes, Your Honor. And Mr. Floyd is here on 2 positions. Obviously, one is the more serious. It's the armed robbery charge. We have been conveyed an offer by the state. It's 15 to serve 10 on the charge of armed robbery with other conditions attached to it. I've conveyed that to Mr. Floyd. I believe that Mr. Floyd is interested in potentially resolving to those terms. What I'm asking the court to consider, however, and I know in speaking with Mr. Floyd, he may want to go forward today. I'm asking the court if we can hear this on the 28th at the calendar call. 2 reasons being, one, I really want to have a conversation with Mr. Floyd to make sure he understands what he's agreeing to and signing up for. In addition, there is a separate unindicted case that is criminal damage to property. So not a serious case. It's something at the jail that I would want to potentially have for a global resolution as well. That way, if he does choose to resolve on these terms, that we would be able to wrap everything up and you would have nothing further to do with Fulton County. So I think this could potentially be something that could be resolved, but I would like this to be heard on the 28th rather than today.
So this 15 to serve 10, that's essentially all encompassing for both cases?
For both cases on the calendar, and I believe Ms. Clark would be rolling the other unindicted case in with that as far as the resolution is concerned. I don't, sorry.
Ms. Clark,
Yes, Your Honor.
and Ms. Clark, Mr. Clark, first of all, yeah, I'll honor that, the calendar call on the 28th. Assuming Ms. Clark's offer is still good until then, but Ms. Clark, can you go over at least the positions 10 and 11, what the maximum is for each of these charges?
Yes, Your Honor. So the for armed robbery, you have 1 to 20 years. And at trial, the state can go life without parole. Obstruction of law enforcement officer.
Wait a minute, life without parole or 20 years?
I believe that it's 10 to 20 on armed robbery or life.
Yeah, that's what I meant to say. Sorry.
Okay. Okay, go ahead.
Okay. Obstruction of law enforcement officer. That is a misdemeanor charge. Is it misdemeanor or is it felony?
It's misdemeanor.
That will be 12 months. Battery substantial physical harm is 12 months. Giving false name is 12 months.
What about the arson charge and the other
The
one?
arson is, I have that. Arson is
I believe it's a max of 20 years.
I
All
think
right.
it's 1 to 20.
Okay. All right, so Mr. Floyd, I'm sure your attorney will go over this with you in detail. But I just wanted you to get a sense that obviously you could be, if you went to trial and if you were convicted by a jury, you could be facing some potentially very big sentences. And I really just want to make sure you were aware of that. But you've already put on the record, the offer is 15 to serve 10. And I'll honor your request, Mr. Clark, and you can talk about it with your client. We can readdress this on the 28th.
Your Honor, the only thing I would ask though is that the state is fine with keeping the offer open until the calendar call, but the state would ask that this case be removed from the August 31st trial calendar. In fairness to the state, because if the defendant decides that he is not going to take the offer, and then we are going to go to trial on the case, then we'll need time to prepare that. I just don't want to be in a situation where we get to the 28th and then he decides he wants to go to trial.
Well, I don't know what to tell you, Ms. Clark. I mean, I've taken pleas when the jury was standing out in the hall.
I understand that.
To come in. So as of now, we're gonna leave everything the way it is. But as we get closer to that date, out of courtesy to all the parties, I will begin to give them an idea of what positions the cases are going to go in and what the chances are. I mean, I'm not gonna stick you with 8 potential trials in one day without having a sense of which one's going to go. Okay.
Okay, so I just need to subpoena my witnesses and prepare it as if it's going to trial.
Yes, Mr. Clark.
Okay.
I was just going to add to I know I'm going to be speaking with Mr. Floyd sooner rather than later at the jail, so I'll be able to communicate with you, Ms. Clark, well in advance of the 28th. So
yeah, I mean, I bet I've done in the 2 years here, I bet I've done 3 or 4, maybe even more, 5 or 6 pleas the day of trial. Now we're doing this a few days in advance we're looking at, but literally I've done it a couple times where I've had to go in and announce to the jury that they weren't going to have to serve jury duty. They were all very upset, but
And I understand that, Your Honor, that's fine. I just will,
Yeah.
you know, I guess proceed and I
Yeah.
guess work the case like I'm going to trial. If he takes a plea on the 28th, great. But we have to, if the case is on the trial calendar, then I have to subpoena my witnesses.
I get it. But
Okay.
we will, we'll remain in contact, and Ms. Robinson's phone number. So,
Okay.
okay. All right. You're excused, Mr. Floyd.
I would take 20 years.
You need to discuss, you got to discuss all this with your attorney. It's not a good idea to be negotiating here over it in front of me, that's for sure. So, all right.
Go to another jail then. You send me to another jail.
I'm having. All right. Sure. Yeah. Are you done, Mr. Clark?
That concludes my business.
Okay, finish. Hasley, is that a plea? That's it.
You mean the one she accused today? Yes, that's a plea also.
23 is going to be a plea. No. Who's going to be a plea? Hasley and who?
Your Honor, there are going to be two, defendant Hasley has two cases. It's going to be a global resolution, so position 15.
Okay.
But also, I accused another case, and that indictment number for that is 23 SC 188943.
All right.
So that was just assigned this morning, Your Honor, for the purposes of this plea.
Give me 1 minute here. So the 23 case isn't on the calendar, right, Kathy? Okay. Okay, so this is. Oh, yeah, that would have been a waste of our time.
The 23 CP case again, or the 23 SC.
And then what's the other one, the unindicted one?
It's aggravated.
Oh, so there's just two cases. I thought there was a third case we're resolving.
No, sir. So the case was unindicted, but I accused it for purposes of this plea. And so the unindicted case
Okay.
number, you probably have this, is 22 CP 206263. But now, since the case was accused by me, the indictment number for the case is 23 SC 188943.
Okay.
And if the defendant has not signed the waiver of rights form as it relates to that indictment number.
She has.
Okay, all right.
The only one that's not signed, and obviously you're by Zoom, is you.
Yes, Your Honor. And Your Honor, I give express permission.
On both of them?
Yes, Your Honor.
Okay. Yes. Okay, so this is position 1522 SC 183759. Miss is it your Sheeker?
Yes, Your Honor.
Your Sheeker Hasley. She is accompanied by her attorney, Mr. Brandon Hornsby Wilson. They're both in the courtroom. We are also going to do another case with this. Another indictment to which she's a defendant, 23 SC 188943. And we have Assistant District Attorney Clark appearing by Zoom. Ms. Clark, you have a negotiated plea to present?
Yes, Your Honor, the state does.
Okay, go ahead.
Thank you, Your Honor. Defendant Hasley, can you please raise your right hand? Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
I didn't hear you.
Yes.
Okay, you can put your hand down. Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
43.
What's the highest level of education or the last grade you completed?
9th grade.
Where did you attend high school?
In Douglas High.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the following offenses under indictment 22 SC 1833759, count 1, aggravated battery, and count 2, aggravated battery? And do you understand that you've been charged under indictment or accusation 23 SC 188943, for which you have waived indictment with 1 count of aggravated assault with a deadly weapon?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Do you understand that if you plead not guilty, have you had an opportunity to review the waiver of rights form and the indictment with your attorney for case number 22 SC 183759?
Yes.
And have you had an opportunity to review the accusation that was filed against you under 23 SC 188943?
Yes.
And for the accusation 23 SC 188943, you did sign and authorize a waiver of indictment for this case.
Yes.
And did you sign a waiver of rights form for this particular case?
Yes.
And did you understand the waiver of rights as it was explained to you by your attorney?
Yes.
And is it your decision to waive your rights for the case 23 SC 188943?
Yes.
And for indictment 22 SC 183759, you signed a waiver of rights form and the indictment for this case.
Yes.
And did you understand the waiver of rights form as it was explained to you by your attorney?
Yes.
And is it your decision to waive your rights related to this case today?
Yes.
And did you sign the indictment which has a plea of guilty on it?
Yes.
Your Honor, at this time, the state moves to have both the indictment and accusation in this cases entered into the record along with the waiver of rights form for each case.
So moved.
Have you had enough time to speak with your attorney about all of the charges in indictment 22 SC 183759, which is the case that involves 2 counts of aggravated battery?
Yes.
And have you had enough time to speak with him concerning the facts and circumstances relating to these charges?
Yes.
Have you had enough time to speak with your attorney about all of the charge in accusation 23 SC 188943?
Yes.
And did you get an opportunity to speak with him concerning the facts and circumstances relating to the charge within this accusation?
Yes.
Would you like more time to discuss the either case with your attorney, Mr. Hornsby Wilson?
No.
I didn't hear you.
No.
Are you satisfied with your attorney's services?
Yes.
Attorney Hornsby Wilson, do you waive a formal reading of the indictment for purposes of this plea, 22 SC 183759?
So waived.
And do you waive any and all defects in the indictment for purposes of this plea?
So waived.
Do you waive a formal reading of the accusation 23 SC 188943 for purposes of this plea?
So waived.
And do you waive any and all defects in the accusation for purposes of this plea?
So waived.
Your Honor, the state is unaware of any outstanding warrants related to the charges in both the indictment and the accusation. Defendant Hasley, do you remember having been arrested on the charges in indictment 22 SC 183759?
Yes.
And do you remember being arrested on the charges that involve in accusation 23 SC 188943?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
The state will provide those under indictment 22 SC 183759. There are 2 counts of aggravated battery. The minimum is 1 year in prison. The max is 20 years in prison. For aggravated assault with a deadly weapon, which is the only charge in accusation 23 SC 188943, the minimum is 1 year. The maximum is 20 years in prison. Do you understand that today just want to make sure. Okay. Do you understand that today you are entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? For a guilty plea under 22 SC 183759, the state will recommend for count 1, aggravated battery, 10 years, 3 years to serve, balance probated, plus the special terms of the plea and special terms of probation below. Count 2, aggravated battery, 10 years, 3 years to serve, balance probated, special terms of the plea on plea and the special terms of probation apply. This sentence runs concurrent with count 1. Special terms of the plea. The Department of Corrections will administer a mental health and psychological assessment of the defendant within 30 days of the final disposition of this case. And the evaluation will be at the state's expense. As part of the terms of the negotiated plea, the defendant will complete all treatment recommendations and take medication if prescribed. Defendant shall remain compliant with all treatment, including medication, while she is in custody of DLC. If defendant has not been transferred to DLC's custody, the Fulton County Jail will conduct the mental health evaluation and psychological assessment within 30 days that this plea is entered. With this plea, the defendant consents to a waiver of her health information to the state, limited to the sole purpose of medical professionals to confirm that she is completing the recommended mental health treatment and that she is compliant with medications if recommended. Special conditions of probation. Defendant shall continue all recommended mental and behavioral health treatment upon her release from custody. And while she's on probation, she is to have no contact with the victim, Lloyd Hewley. No drugs unless prescribed. Defendant is subject to random drug screens. Defendant must not possess any weapons or drugs or firearms. Defendant must be gainfully employed within 150 days after her release, and she will provide proof of employment to her probation officer by providing timesheets, etc. If she does receive disability pay or federal economic assistance for one of those, she is exempt from the work provision. For the terms of the plea for accusation 23 SC 188943, the plea terms run concurrent with the 22 SC 183759. The plea terms: aggravated assault with a deadly weapon, 10 years, 3 years to serve, balance probated, plus the special terms of the plea. And on probation, the special conditions of the plea. The special terms of the plea are the same as the ones read in for the indictment, and the special conditions are the same. Is this your understanding of the terms of the plea in this case?
Yes.
I didn't hear you.
1 second.
Okay, sir.
So it's her understanding she'll get credit for the time that she's already served. Is that
Correct. I'm sorry. She will get credit for time served in both of the cases.
So can you ask the question again?
Okay. So is this your understanding, Defendant Hasley, of the terms of the plea?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge in the indictment?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on the charge in the accusation 23 SC 1888943?
Yes.
Do you understand that as there are multiple charges in the indictment ending in 759 to which you're pleading guilty today, the court also has the right to run those sentences consecutively, meaning one after the other?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole?
No.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so will result in new criminal charges for which you face a sentence of between 1 and 10 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face up to a 15-year custodial sentence consecutive to the sentence for the underlying felony?
Yes.
Do you understand that as a convicted felon, you can never possess a firearm or weapon at any point in the future, even after your probation ends?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your own behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Defendant Hasley, is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes.
I didn't hear you.
Yes.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
As to indictment number 22 SC 183759, how do you plead to the charge of aggravated battery in count 1 of this indictment?
Guilty.
How do you plead to count 2 of this indictment, aggravated battery?
Guilty.
In accusation 23 SC 188943, how do you plead to the charge of aggravated assault with a deadly weapon?
Guilty.
Are your guilty pleas freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal these guilty plea convictions?
Yes.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty pleas today, you must do so by filing what is called a habeas corpus petition? Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes.
At this time, the state will provide a factual basis.
Your Honor, and I hate to interrupt you. If it's okay, we'll stipulate to the factual basis in both of the cases, if that's okay with you, Your Honor, unless you want to just hear it.
No, I think we better, as much as I'd like from a time efficiency, I mean, it is felonies and she's going to doing some time for it. So we need to hear the factual.
Okay, Your Honor.
All right, go ahead.
Okay. At this time, the state will provide a factual basis for the felony plea in 22 SC 183759. If this matter had went to trial, the state would have been able to prove that beyond a reasonable doubt that on June 6th of 2021, at the incident location of 1444 Stokes Avenue in Atlanta, Georgia, on the night of the incident, both defendant Hasley and the victim, Mr. Hewley, were sleeping on a mattress that was on the porch of above listed location. Both defendant Hasley and Mr. Hewley were homeless at the time. When officers arrived, Mr. Hewley, the victim, was bleeding from his leg and hand. Mr. Hewley told officers that he was asleep when he woke up and saw defendant Hasley sitting next to him on the bed and realized defendant Hasley had stabbed him. He stated that prior to falling asleep, Hasley had been acting crazy by hitting on him, taking his blanket and throwing food off of the porch. Defendant Hasley told officers that Mr. Hewley left and came back, but she stabbed him. However, the mattress was bloodstained, consistent with the stabbing occurring on the mattress. Officers noted that defendant Hasley seemed to be excessively intoxicated. When officers arrived, defendant Hasley was sitting on the mattress that Mr. Hewley stated she stabbed him on. A witness, Alan Stafford, who was also sleeping on the porch, heard a verbal dispute between Mr. Hewley, the victim, and defendant Hasley prior to the stabbing. Stafford stated that the two were arguing outside when defendant Hasley began throwing food at Hewley and cussing him out. Shortly after that, Hewley woke him up screaming, "She stabbed me." However, he did not see defendant Hasley actually stab him. During victim contact, officers victim contact with Mr. Hewley, he told them that he was not in a relationship with defendant Hasley, but she would come around from time to time. This was the basis for this case being originally signed to the DV unit. The victim told officers that he didn't remember arguing with Miss Hasley that night because he had been drinking also. He told officers that he had used a cane for approximately 2 months. He also showed officers a scar on his hand from the stabbing. And he also told officers that there was a scar on his leg. For the accusation 23 SC 188943, if this matter had went to trial, the state would have been able to prove beyond a reasonable doubt that on February 1st of 2022, officers were dispatched to the incident location of 1456 South Gordon Street Southwest, Atlanta, Georgia, in Fulton County. Upon arrival, officers spoke with the reporting party, the victim, Mr. Henry Mapp, who advised that defendant Hasley came at him with a knife. Mr. Mapp advised that he was in the kitchen cooking food, and defendant Hasley came into the room, said that they were talking about her, and then she knocked over the food, picked up a knife, and tried to attack him with a knife. Mr. Mapp advised that he ran to his room to get his gun to defend himself against Miss Hasley. Miss Trebia, which is spelled Traebbia, Perry, advised that she tried to get Miss Hasley to leave the location, but she came and started arguing with Mr. Mapp, and then she saw Mr. Hasley come at him with the knife. Miss Hasley was placed into the custody and charged accordingly. Incident to arrest, the knife was recovered from Miss Hasley's suitcase and turned into police property as evidence. The state will provide for the defendant's criminal history. The defendant has 15 cycles of arrest for the GCIC. Excuse me, Your Honor. She has a possession of cocaine conviction from 2005, an aggravated assault conviction, and that was in Fulton County, aggravated assault conviction from 2007 in Fulton County. He has a battery conviction in Fulton County State Court, February 1st of 2013. A state court battery conviction in Fulton County State Court, December of 2014. She has a Your Honor, that looks like it's that's it as far as the criminal history for the defendant, Your Honor.
Okay. Mr. Hornsby Wilson.
Your Honor, before you is Ms. Hasley. She has been incarcerated for roughly 783 days on these charges. She is willing to accept responsibility for her actions. While incarcerated, she's actually been a part of the New Beginnings program, which Ms. Hasley, if you would like, can tell you a little bit more about that. She is very proud of that. And she hopes to continue in that program while she is incarcerated. Your Honor, we just ask that you accept, well, part of the reason that we believe that these incidents happened was due to her homeless status. And so she has spoken with her brother because she does not want to go back to that area. And so her brother lives in Dublin, Georgia. And so upon her release, that's who she's going to be living with. And so she believes, and I believe also, that being moved outside of that environment will do wonders for Ms. Hasley. And so we ask that you accept this negotiated plea. Oh, also, she would ask that by my calculations, she'd only have roughly 10 months left. And I know that Your Honor doesn't necessarily have control over this, but the Department of Corrections has control over this. But she would at least ask that if you could put in the order if she could stay here in Fulton County so that she can continue with the New Beginnings program. I don't know if she were to move to another jail or another prison, if she would be able to continue with that program. I imagine she would be, but it would be a little bit more difficult.
Tell me about the New Beginnings program.
Yes, sir. Okay. First of all, I'm a spiritual advisor. I'm a spiritual advisor. I'm on the board. I've been in the program since I came. since I've been incarcerated. We take GED classes, which is I have like 8 more hours left to take my GED test. I should show my lawyers and my test scores. We take counseling every Friday. Tuesday, we take computer classes, we take cosmetology classes, we take anger management, take substance abuse, and we take like one-on-one sister to sister. Like if we have conflicts, whatever, we just talk it out one-on-one. We have Sister Covenant where we go by the rules, the Sister Covenant. We do Armor to God. We do devotion every morning and things like that. And I also have a counselor, Mr. Watson, Ms. Stevens, and my lawyer has the counselor number. And they also help me with resources and things like that as well. So yeah, and it helps me a lot. I have learned, my abilities. I take responsibility of it, and I just want to continue with the program because it helps me a lot.
What, it seems like at least in jail, you've got a lot of discipline and a lot of accountability, and you've created some of that accountability by joining the organization. How do you plan to continue that when you're living in Dublin with your brother?
I asked my counselor to transfer me the information down there with my brother so I continue with it. It goes along with me.
So I've been to Dublin many times. It's quite a bit different than Atlanta. So.
Yes, sir. I know.
Well, it looks like, I mean, just glancing at the indictments, reading through them, that there's some anger management issues, and you feel that this program has helped you work through that.
Sir.
Ms. Hasley, do you understand the nature of the charges against you?
Yes, sir.
All right, so you've just heard from Assistant District Attorney Clark explain all the rights you give up by this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilt?
Yes, sir.
You understand the court is not bound by the recommendation or the plea agreement, and I can sentence you as I deem appropriate.
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Mr. Hornsby Wilson, are you satisfied that your client is competent and understand the plea is voluntary and that there's sufficient factual basis for entering the plea?
Yes, Your Honor.
I find that there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I accept your guilty plea and sentence you to the recommended sentence as follows. So on 22 SC 183-759, the first count of aggravated battery will be 10 years. 3 years to serve, balance probated. Count 2, the second count will also be 10 to serve 3, balance probated to be served concurrently. And then on the 23 SC 188-943 indictment on the one and only count of aggravated assault with a deadly weapon, that will also be 10 to serve 3, balance probated. And all of these will be served concurrently. And you will, as you mentioned before, be given credit for time served. As far as the special terms, you are to get, and I will put in the request that you can serve your, how many months? You say 11 months in the 10 months in the Fulton County Jail. I'll put in that request. But if you do go to the Department of Corrections, well, either the Department of Corrections or the Fulton County Jail will be instructed to do a mental health assessment within 30 days. And you are to follow any recommendations and treatments, including medications that are that come as a result of that evaluation. You consent to access to your health information, but that consent will be, that waiver will be limited to the authorities ensuring that you are remaining compliant with your medication and other recommendations of your mental health evaluation. No contact with either of the victims, no weapons, drugs, without a prescription, that includes knives. And I read those indictments. You will remain gainfully employed within 150 days of your release from confinement. If you receive disability pay or other federal assistance, you'll be exempt from the work requirement. Have I missed anything?
No, Your Honor, you got everything. You always exceed my,
Your expectations?
yeah, not my expectation. You always exceed, above and beyond.
I'm kidding. I'm just giving you a hard time. So, anything else?
So on her current booking number, there's 500 and something days. I just want to make aware of the court that her other booking number, so that she gets credit for the full amount of time, is 2107646. And so that would be the booking number for her first time, because she was released on bond before she was picked up for the second.
Oh, okay. Okay. So she would be, as far as you're concerned, we'd be adding those together.
Yes.
So she,
because right now I believe it's only
just so I follow it. So she served, what'd you say, 276 days?
224 days.
224 days, got out on bond, and I'm assuming her bond was revoked as a result of this other.
I believe so. Or she was arrested.
Arrested.
Yes.
Yes, yes, Your Honor. So the other one, 224 days.
Okay, well.
Uh-huh. So a total of 882, right, Mr. Wilson? Hornsby Wilson?
700. My math was off originally.
Oh, okay.
782 days, I believe is what it'll come out
Okay,
to.
so she is supposed to receive credit for 782 days.
Correct, yeah.
Okay, anything else? All right, you're excused. Good luck with your program. Good luck when you get out. Good luck moving to Dublin. And I hope that you're able to, you've gotten the tools that you need to be able to deal with your anger management issues. Okay, Miss Hazy?
Yes, sir.
Hasley?
Thank you, Your Honor.
All right, bye-bye now.
Thank you.
Who? What position is Tucker? What position is he? Yeah, yeah. All right, so that's it, right?
Yep.
Okay, we are adjourned. Have a good day, rest of the day. See you later, Miss Clark.
Thank you, Your Honor.
I'll get out of here. I'm sure y'all got other things to do right now. Got a couple things on your calendar, right? Well, the evidence is there. I rule in favor of the deputy.
We'll just give them, we'll call them out and give them the right back. We'll see who. See what you.
These guys have a few other things to be doing right now than chasing down your false alarms, Kathy.
Okay, well, who's in this? Then you know it worked. They can run it back. Let's see what it was. So you can delay it.
No, I was gonna say, what we can do is I can even go on here. That day, or I can just let the bill determine credit, or do you want to be specific?
Well, I mean, as long as we got the booking number, that should be fine.
Yeah, they should have a booking.
So, yeah, but, because I looked on the, on Odyssey, but it only gave her credit. With the booking number, she got credit. you want to put? For the first one. June 10th.
And then pick up February 2nd. Okay. 2 weeks back. Yeah, he did. Yeah. He just came to fix the thing. But what is it? That's one more.
See y'all, we'll do it again tomorrow.
Oh, can we go see?